Hello, everyone, and welcome back to this lecture series on Bharatiya Saksh Adhiniyam 2023. I'm Dr. Mangal Singh Bisain, Associate Professor at Department of Law, School of Legal Studies, Central University of Kashmir. In this session, we will be discussing a very important and rather an emotionally intense topic, that is the legal status of dying declaration in India. Now, this concept of dying declaration is not only vital for from the examination point of view, but also holds a significant place in criminal trials, particularly in cases involving homicide or suicide, or let's say fatal injuries. Previously, that is prior to the Bharatiya Saksh Adhiniyam, this provision was dealt under Section 32, subsection 1 of the Indian Evidence Act, but now this is dealt under Section 26A of Bharatiya Saksh Adhiniyam. Right. So let's start with the topic. Now, what is dying declaration? What exactly mean is how dying declaration, the declaration made at the time of dying, works in India. Now, the definition of dying declaration is a dying declaration refers to a statement made by a person who is on the verge of death, who is on his deathbed, regarding the cause of their death or the circumstances leading to their death, leading to it. Right. For example, suppose a woman is set on fire by her husband. At the hospital, she's admitted to the hospital. At the hospital, she tells the magistrate that her husband poured kerosene on her and lit the match. If she dies later on, after making this statement, if she dies, her statement is treated as a dying declaration and the husband can be prosecuted solely on the basis of this dying declaration. Section, as I said, Section 26, Section 26, Clause A of Bharatiya Sakshi Adhiniyam 2023 talks about dying declaration. Now, what does Section 26A say about dying declaration? As I said, Section 26A, the title of the section is cases in which the statement of relevant facts by a person who is dead or cannot be found, etc., is relevant. Right? That is a title which is given to section 26A. What does the section says? When it relates to cause of death. That is a subtitle that is given to the section. Now, what does the section says? When a statement is made by a person as to the cause of his death or to any of the circumstances of the transaction which result in his death, in cases in which the cause of that person's death comes into the question, such statements, now this is important, such statements are relevant whether the person who made them was or was not at the time when they were made under expectation of death, and whatever may be the nature of the proceeding in which the cause of death comes to into the question. Now, what does this section 26? I know the section is a little bit longer and a little bit technical in nature, technical to understand, but let's discuss as to what does the section say. Section 26, Clause A. Now, Section 26, Clause A is an exception to the hearsay rule. Hearsay rule, Hearsay. Hearsay rule means something which is heard. It is an exception to the hearsay rule. Now, normally, the statements made outside the court of law are not allowed. as evidences. But if a person is dead and they had made a statement about how or why they died, that statement becomes legally relevant irrespective of the place at which they are made. These statements becomes legally relevant even though the person cannot can no longer testify before the court of law. He cannot come before the court of law and testify his statement, right? He may not be in a position to do so because he is dead, but still such type of statements is important. This is called as a dying declaration. Now, the purpose of this section is to allow the voice of the deceased to be heard in the court of law. It ensures justice in cases like murder, suicide, or dowry death, or suspicious death, death under suspicious circumstances, and so on. It is uh, largely based on the belief that a dying person will not lie. A dying person will not lie. This is something that is believed by the Indian judiciary as well. That is the reason why the maxim that is displayed on the slide suggests a man will not meet his maker, that is God. A man will not meet his maker with a lie in his mouth. That is something that is believed since ages, right? So, in simpler words, a person will speak only truth at the time of his death when he is dying, right? That is a general belief. Now, what evidentiary value does dying declaration hold? Is a dying declaration enough to convict someone? So this is an important question which we need to answer here. The explanation first. One of the most frequently asked question. This is one of the most frequently asked question whether a statement which is made by a person who is dying, does that statement holds so much weightage that another person, that is the accused person, can be convicted solely on the basis of that statement? The answer is yes. A dying declaration can be a sole basis of conviction provided, now there is a condition applied, provided it satisfies certain legal and evidentiary standards. So it is not a 100% acceptable evidence. There are certain exceptions, there are certain criteria which are required to be followed by a dying declaration as well, right? The Supreme Court has constantly held in different cases that if a dying declaration is found voluntarily, it is consistent with the facts of the case, and is made when a person is of fit mental state, it does not require any further collaborations. If these conditions are there, what are the conditions? It is made voluntarily, it is consistent in nature, it is made with with sound state of mind, then it does not require any further collaborations, right? Any further evidences. This means no other supporting evidence is needed as long as the court finds it relevant, it reliable, right? So satisfaction of court is of utmost importance in case of dying declaration. Now this principle was firmly established in case of Kushal Rao versus State of Bombay, the case of 1958. In this case, it was held by the court of law that a truthful and voluntary dying declaration can be a sole basis of conviction, right? Truthful and voluntary dying declaration can be the sole basis of conviction. Take the example. Now let's take an example. A woman is set on fire by her husband. At the hospital, she is conscious and in stable condition. A magistrate comes to her and he records her statement in presence of certain witnesses, let's say a doctor and her relatives. She, in her statement, clearly states that my husband poured kerosene on me and lit the match because I refused to give him dowry money. This is a statement that is made by her. And after the magistrate records the statement, the magistrate leaves, and let's say 2 days later, the woman again suffers some critical condition and she dies. She dies because of the burns she has suffered. There is no eyewitness, but her dying declaration is consistent, detailed, and made voluntarily in the presence of magistrate and other people. And therefore, in this case, the court can convict the husband solely based on this dying declaration. There may not be any witnesses at the time of incident, at the time when the husband lit the match. Right? At that time, let's say there were only two people, a husband and wife, and the husband lit the match and burned the wife. There may not be eyewitnesses at that point of time, but when she made the statement, she made the statement voluntarily. She made the statement with conscious mind, sound mind. She made the statement to the magistrate, and while making the statement, the magistrate and few other members were present. This gives the court satisfaction and assurance that the statement that is actually made by a woman and therefore it is reliable. And based on that statement, the husband can be punished. Now, why does this kind of situation works? The court in such type of situations assumes that the person who is about to die have no motive, have no intention to lie. Such statements are considered made under the shadow of death, which brings a moral seriousness. But they are still subject to judicial scrutiny. Remember this thing that they are still subject to judicial scrutiny. That is, the judge must be satisfied with its genuineness. Okay. Now, there is an important caveat here. If a dying declaration is inconsistent, you can say that these are the exceptions. If the dying declaration is inconsistent, it is influenced, it is ill motivated, or it is not made in a fit state of mind, in a sound state of mind, then the court cannot rely on it. Right? The court cannot rely on it or it alone. The court may ask for additional evidences, additional data. Right? Only then the court will take the dying declaration into consideration. So, in general, yes, a dying declaration can be enough, but only if it passes the tests of reasonability, reliability. Okay. Now, the next part of a discussion, that is some of the important case laws. Now, the first case, Pakala Narayan Swami versus Emperor, the case of 1939, a very old case, but what do you say, a remarkable one, a landmark one. In this case, it was held by the court that the dying declaration is not limited to the moment of death. It can be made even days before, as long as it relates to the cause of death. Right. So if a person is making a dying declaration days before his or her death, then that can be a valid dying declaration. It is not necessary that the person should make a dying declaration and he should immediately die. No, there may be a time gap between the two. In the next case, that is Kushal Rao versus State of Bombay, the case of 1958, it was held by the court that a dying declaration can form a sole basis of conviction if it is truthful, voluntary, and made in fit state of mind. Now, it also emphasized that corroboration is not mandatory if it is made with if it is a truthful, voluntary, and made in fit state of mind. In case of Lakshman versus State of Maharashtra, the case of 2002, it was held that medical certification of mental fitness is desirable but not mandatory. Desirable but not mandatory. See, try to understand the situation. If a person is on his bed, there may be a situation that he is not of very sound state of mind. It is not of he or she is not of a very normal state of mind, right? He or she may be suffering from some trauma. But in this case, the court said that if the medical certificate is available, then that can be taken into consideration, but it is not a mandatory condition. The key is whether the person was mentally alert, conscious, and was aware about making the statement. That is the only criteria at the in case of dying declaration. The next case, that is Mukesh versus State, that is popularly called as Nirbhaya case, the case of 2017. It was held that the victim's multiple dying declarations were consistent and became crucial evidence in upholding the death sentence of the accused. Right? In this case, there were multiple dying declarations, and they were all taken into consideration in upholding the death sentence of the accused people. It showed that how dying declaration can be decisive, especially in sexual violence and brutality cases. Right? So the case stands a landmark is of landmark importance in different perspective from different perspectives. Now, what are the different forms of dying declaration? So as you can see, there are different forms, that is oral declaration, written declaration, gesture, and video or audio recording. Oral declaration, as the word itself suggests, spoken words to the doctor, to the policeman, to the relatives, or to the magistrate. The statement made to the magistrate is of utmost importance, right? But if the magistrate is not available at the time of making of the statement, then the statement can be made to the other personnels as well, also, right? But that again has to be corroborated with other evidences. Second one, written statement signed by the declarant. That generally happens when the magistrate is present, and magistrate records the statement and takes the signature of the aggrieved party, of the victim. Then there is gesture based or sign language, even nods or even movements, or even movement of body of the head or the hands can be taken as dying declarations, right? It can be recorded by the magistrate. Then comes video and audio recording. Now this video and audio recording is nowadays gaining popularity, and they are considered to be the most reliable one of the most reliable methods of recording of dying declarations. Now, conditions for validity, as we have discussed earlier as well, the declarant, the person who is making the dying declaration should be conscious and mentally fit. The statement should be voluntary and not influenced or coached. If recorded by a magistrate, it holds higher evidentiary value, and any inconsistency can weaken its reliability. If these situations are present, then the dying declaration is considered as a is of valid evidentiary value. Then comes when dying declaration may be rejected by the court of law. If a person was not in a fit state of mind, or if there are multiple inconsistencies in declaration, right? Then there is, if a statement appears to be coached or influenced or biased or made with an ill intention, And finally, if it lacks clarity or specific details relating to commission of the wrongful act. In such type of situations, the dying declaration may be rejected by the court of law. Okay. Then comes the recent trends or recent developments in the field of dying declaration in the topic of dying declaration. The courts now accept digital dying declaration as well as we discussed. Now video and audio recording of dying declaration can be taken into consideration by the court of law. They stand to be the, let's say, the second paramount important form of taking of dying declaration. The first is always the dying declaration made before the magistrate. The second is if the magistrate is not there, then the video recording or audio recording are also reliable source of dying declaration. Methods of recording of dying declaration. In custodial death cases, dying declaration can be are being seen as crucial to ensure accountability. And in the Delhi High Court accepted a WhatsApp voice message as a valid dying declaration, making the making a new era of digital admissibility. Now, this was about dying declaration. With this, I conclude this session on the topic of dying declaration, and I thank you all for your patience listening. And I hope you are now in a better position to understand the legal status and practical implications of dying declaration in India. I suggest that you go through the different with the go through the what do you say Bharatiya Saksha Adhiniyam, the law itself, as well as different cases, if you want to have an in-depth understanding about the subject. So, with this, I conclude this session on dying declaration. Thank you.